Good morning. I'm David Ratner. I am a member of the CCCBA Board of Directors. On behalf of the Contra Costa County Bar Association, I welcome you to the 27th Annual MCLE Spectacular. We hope you're feeling updated, upleveled, and uplifted. This session, your professional responsibilities involving cybersecurity, how to prevent ethical, technical, and financial disasters, is presented by the CCCBA and the senior section. A couple of quick housekeeping items. One, the materials and evaluation forms for this program can be downloaded from this session page through the Files tab above the chat. Two, your attendance certificates will be available after the Thanksgiving holiday. For further information on how to access them, please see the FAQs tab on the events main page. And three, for assistance with any technical difficulties, also head to the FAQs tab on the events main page. As a reminder, our event and program sponsors are a very important part of our CCCBA community. They make it possible for us to produce events like this. Please support us by supporting them. And please take time during the spec to visit their online booths. Don't forget, while this program is pre-recorded, the speakers are available live in the chat to answer your questions during the presentation. They will also be available in the live Q&A immediately following the presentation. At this time, I would like to pass the program over to Judge Richard Flyer, Senior Section President, who will introduce today's speakers.
Good day. So, at the beginning of personal computers, cyber communications, and electronic storage, IT was hailed as the genie opening a new frontier for practitioners. We are now seeing that these cyber systems are fertile fields for testing information security, ethical concerns, and unauthorized financial access. What's a 21st century lawyer to do? But we are blessed today with three experts in risk management, ethical consideration, and cyberspace. Chantal Rees is the founder and president of Rees & Rees Insurance Services, Inc. She specializes in custom coverage for California business owners, and her goal is to help employers truly understand their insurance by offering a proactive educational approach that helps them discern how a policy would function in the event of a loss, including a cyber loss. Joshua Bevitz is a partner in the law firm of Niemeyer Dillion, which is in Walnut Creek, Las Vegas, and Newport Beach. And he's a legal strategy pioneer who develops creative litigation solutions to address the individual needs of each of his clients. He has experience litigating cases in both state and federal courts, and previously he worked for the U.S. Department of Justice Criminal Division, the Office of International Affairs in Washington, D.C. While in law school at Hastings, he was also the executive editor of the Hastings Law Journal. And Josh will have to tell us what it's like to earn degrees at Trinity College in Dublin, take courses there, Ireland, and Charles University in Prague, Czechoslovakia. Robert Gillette is an executive at Ensight. Ensight manages the IT for over 250 companies, either replacing, managing, or collaborating with IT teams internally in those companies. The primary focus is on creating stable and secure IT environments and reduce computer problems. Broadly speaking, Ensight's clients expect their technology to perform. They understand that technology is leverage and use it to raise the quality of everything else they do. They count on Ensight to deliver a predictable result that meets that expectation. The senior section sponsored this particular program because of its critical need for each of us in a 21st century world faced with many cyber problems and many cyber issues. The senior section represents a broad cross-section of attorneys who have been licensed to practice law for at least 30 years or are 60 years of age. That's a very select group, you can understand. Given our experience, the senior section offers members not only opportunities for advancement in their knowledge of the law, but also social occasions for camaraderie with old friends and new acquaintances. And now I'd like to turn the program over to Joshua, who will begin our presentation.
Thank you, Judge Flyer, for the kind introduction. My name is Joshua Bevitz. I'm an attorney with Newmeyer Dillion. We have offices in Walnut Creek, Newport Beach, and Las Vegas. My practice centers around construction, insurance, real estate, and cyber issues. And today we're going to talk about ABA Formal Opinion 483. It relates to an attorney's obligations as to cyber attacks. It was issued in 2018. Now, the frequency of cyber attacks on law offices is only going to increase because you have valuable confidential data in your electronic files. Now, ABA Formal Opinion 43 clarifies an attorney's obligations to prepare for cyber attacks, to safeguard information provided to them, and to respond appropriately if an attack occurs. Now, the opinion is based on Model Rules 1.1 competence, 1.4 communication, 1.6 confidentiality, 5.1 attorney supervision, and 5.3 non-attorney supervision. So Formal Opinion 43 states that lawyers must employ reasonable efforts to monitor technology and office resources connected to the internet, external data sources, and external vendors providing services related to data and the use of that data. In other words, you have to protect your electronic client files. Now, what is a data breach? A data breach involves the misappropriation, destruction, or compromise of client confidential information, or a situation where a lawyer's ability to perform legal services for which the lawyer was hired is significantly impaired by the event. Each of those scenarios is one where the client's interests have a reasonable possibility of being negatively impacted. When a data breach occurs or having a substantial likelihood of having occurred involving material client information, a lawyer has a duty to notify clients of the breach and to take reasonable steps consistent with their obligations under the model rules. So while the ABA model rules are not binding on California attorneys, California and other states will likely issue similar rules, and practitioners should be prepared to follow the rules. And importantly, while an attorney's legal duties are separate from ethical duties, an attorney should also comply with their legal duties. So if personally identifiable information of a client is affected, an attorney should comply with any applicable privacy laws and other statutes, including as their notification requirements. In California, that's 1798.82 of the Civil Code section. So the first step is to ensure reasonable computer protections are in place. And this is centered on the duty of competence and confidentiality. Model Rule 1.1 states, a lawyer shall provide competent representation to a client, and competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So further, comment 8 to that rule reads, to maintain the requisite knowledge and skill, a lawyer must keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing education requirements to which the lawyer is subject. Now, Model Rule 1.6c states that lawyers must make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. So every law firm should have current technology protecting their computer systems, including those office resources connected to the internet, as well as external data sources. A firm's IT department should perform periodic regular reviews to determine whether additional protections are warranted and whether the current security system in place is reasonable. In addition, the IT department should monitor whether patching existing protections is necessary based on newly developed cyber attacks. At least one technically competent partner should be assigned as a liaison to the IT department to ensure its responsibilities are being met. If a law firm does not have an IT department, an outside cybersecurity firm should be consulted. It's important to note that a successful cyber attack on a law office does not mean an attorney has breached his ethical duties. it's a reasonable standard. So we'll keep coming back to that. A bar will look to whether or not an attorney acted reasonably, whether or not the attack was successful. All right. Very important is to train and test your attorneys and staff. And this is based on Model Rules 5.1 and 5.3. And this is because most cyber attacks that are successful are not frontal attacks on a computer system. Usually they are a result of phishing emails. They get a user to click on a link, it tricks them, and all of a sudden the hackers are in and can get your client's information. So as a result, all users should be regularly trained regarding what type of cyber attack vectors exist and what attackers try to do to trick users. However, law firms should take matters a step further and conduct their own phishing campaigns to test their employees. My firm does that with us. And if you click on the link, it says it fooled you, and you'll get a call from the IT department. I haven't fallen for this except for one time. I was looking through my emails on my phone. I get an email from the court saying I had an OSC hearing scheduled and I was going to be sanctioned, and I panicked and I clicked the link. So we always can learn. So numerous third-party cyber companies do provide this service. So if you don't have the resources, internal resources to have it done, you should hire one. Trial by error is often the best way to learn. All right, very importantly is you need to ensure that your third-party vendors have reasonable cyber protections in place. And this is based on Model Rule 1.6. Law firms should ensure that external vendors have reasonable security protections in place to protect the data provided to them. If a vendor does not have reasonable protections, the vendor must be required to implement such protections immediately, or the firm should retain another vendor that does provide such protections. Law firms can be held responsible to their clients if they do not ensure proper vendor security exists. One approach for law firms is to contractually require vendors to adhere to a specific cybersecurity framework and to provide the law firm the right to audit them. All right, next, limit the amount of time client files are retained. The longer you retain client electronic files, the longer they are susceptible to attack. Every law firm should have a written policy on document retention. It should be monitored and followed. And that does apply to both hard copies and electronic files. So the amount of time a client file will be retained can often be the subject of the initial engagement letter. So the client is aware how long its files are going to be retained. Know how to respond. This is very important. Law firms should have a plan in place to deal with cyber attacks when they happen. And this is based on Rule 1.1. Having an effective, comprehensive plan will allow a law firm to halt the attack and minimize any damage and disruption as soon as possible after the attack becomes known. The plan should specify each step that takes place and who is responsible for taking it. High-level partners should be assigned to the response team to provide leadership and permit executive decision-making to occur very quickly. Moreover, Formal Opinion 483 specifically states that a competent lawyer must make all reasonable efforts to restore computer operations to be able to begin service the needs of its clients. Okay, next, Rule 1.4A3 provides that a lawyer must keep the client reasonably informed about the status of the matter. Rule 1.4B provides a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Formal Opinion 43 states that cyber attack notification requirements will depend on the type of breach that occurs and the nature of the data compromised by the breach. Notification to the client is required if material client information has been accessed, disclosed, or lost in a breach, or if it is reasonable to suspect as much. Remember, if your system is impaired, it affects your ability to provide legal services to your clients. So you have to get it back up and running as soon as reasonably possible. One of the key steps in the response plan should include discovering what occurred and whether client data was compromised. This step is vitally important so that the law firms can notify clients in a timely fashion if their data was taken or destroyed. The notification should be sufficiently detailed so that the client can decide what next steps, if any, should be taken as a result of the cyber attack. Law firms should also notify their clients of any efforts to recover the data and what additional protections, if any, are being put into place. So for current clients, cyber attacks on law offices will only increase in frequency, and they're increasing across the board around the world. So law offices are no different. So attorneys should take the following actions and do all of the following. 1, protect your computer system and ensure your vendors are doing the same. 2, have an incident response plan in place to stop the attack and minimize the damage. 3, conduct an investigation to determine exactly what happened. And 4, notify and advise clients as required. Now, it's a bit different for former clients, and I'll explain why. So Formal Opinion 43 treats former clients differently because it determined that the model rules do not address an attorney's duty to notify a former client of a cyber attack. Model Rule 1.9c requires that a lawyer who has formally represented a client in a matter or whose present or former firm has formally represented a client in a matter shall not thereafter reveal information relating to the representation except as the rules would permit or require with respect to a client. When electronic information relating to the representation of a former client is subject to unauthorized access, disclosure, or destruction, the model rules provide no direct guidance on a lawyer's obligation to notify the former client. Rule 1.9c also provides that a lawyer shall not reveal the former client's information. It does not describe what steps, if any, a lawyer should take if such information is revealed. As such, the committee was unwilling to require notice to a former client as a matter of legal ethics in the absence of any black letter provision addressing it. However, as mentioned, the ABA recommends that the amount of time client files are retained after the conclusion of a matter should be limited as agreed to as part of the initial engagement agreement. Again, even though an attorney may not have an ethical duty to notify a former client of a cyber attack, an attorney should still comply with notification requirements pursuant to any applicable privacy laws and other statutes. Meaning, even if you don't violate the ethical rules, you could still be subject to civil liability if a client sues you, if its information gets out and results and a financial loss results because of it. So failing to take the steps outlined in this presentation could not only result in a breach of an attorney's ethical duties, it could lead to civil liability. Law firms must proactively protect themselves and their clients' confidential data from cyber attacks. Now, to get into the technical aspects of cybersecurity, I will introduce you to Robert.
Thank you, Josh. Let me just share my screen and we'll get started here. Excellent. My name is Robert Gillette. I'm an executive here at Endsight. And today we are talking about cybersecurity. At least that's what I'm talking about today. And specifically, I want to talk about how did we get here and how did it get so bad? And then what are we supposed to do about it? And I mean we in terms of us as technology people and you as law firms and your clients, because we're all interconnected. There's no such thing as being isolated now. We're all on the same IT team, so to speak. And security is a community resource. It's a herd immunity, which I don't know if we're spending any time talking about that these days. But anyways, the challenge is cybersecurity is just a very misunderstood thing. We think we know what the bad things look like. Sometimes we're right. And we think we understand how it affects us. And sometimes we're right. But we're clearly not doing something right because it's getting worse. It's not getting any better. Bad actors are financed and incentivized to find ways around my traditional security defenses. And it's leading to something we've come to call the fog of more, where we both think it's common and not common and can't be stopped, but totally should be stopped. And I just keep hearing from people over and over that they feel like this. They feel like a animal being stalked by a predator from whom they have no defense. And part of this is actually my fault. Well, not my fault specifically, but the fault of us IT professionals, because for decades, we had a tool, a plan that worked. And this traditional way of thinking about cybersecurity, it did a really good job for like decades. It was to build strong walls and keep the bad guys out. And it worked pretty much for, the whole time we've been doing it. If you did it right, it would work. And then the bad guys, they found ways to work around us and make our traditional tools completely useless. They just invented these new ways to evade the security we put in place. They were able to bypass and infect backups, which was a game changer because now there was no safe place to hide anywhere. They invented code that was able to work on its own to create vulnerabilities that we didn't know existed yet and to exploit them in ways that we could only see once. And then they started working together in peer groups to find out what was working and what wasn't. And certainly AI and machine learning aren't helping. And the moral of the story is the castle just doesn't keep us safe anymore. And when we look at the data, it didn't happen slowly. We saw lots of vulnerabilities, reported to us and from other vendors all the time. But as you can see from the graph, in 2017, there was a dramatic uptick and it keeps going up. What happened? What changed? Well, like most things in life that don't go well for someone, it was money. Bitcoin, not what it was invented a while before that, but right around 2017, we hit this spot in history where the bad guys figured out I didn't have to get cash in bags in a trash can in Central Park anymore to exploit you. I could do it anonymously online. And it had gotten to the point where you could reliably get people to change their dollars into Bitcoin. And the dam just broke. I mean, and it broke in a big way. Companies like Sophos are telling us they're seeing like almost 500,000 attacks per day. And that's just the people they're watching. And the really scary part is that 3/4 of those attacks are done by like polymorphic code, which means it's changing and inventing itself every time it attacks. And whether the attack is successful or not, it then changes the code so that we'll never see it again, which is a big problem because in the cat and mouse game of security, where we are the cat, what do you think it's going to be like where 3 out of every 4 times a mouse shows up, you have to re-educate the cat what a mouse is? That's what cybersecurity started looking like in 2017. Our traditional tools became pretty much useless. And it's not just the big businesses that are having this problem. We read about them in the news, but believe it or not, half of the people that are doing this are targeting specifically businesses with less than 100 employees. Not just because they don't have the sophistication or they're afraid of the risk of going after the big boys, the Fortune 500, but small businesses and small and medium-sized businesses actually are less likely to adopt the changes necessary because of the cost, because of the institutional knowledge required. They don't have the right employees to truly understand this. And it just has led to this big problem for small and medium-sized businesses. I mean, it's a big problem for everybody, but people used to think, well, I'm too small, I'm not important, who's going to bother me? And unfortunately, it's not just that, it used to be that computers couldn't tell the difference, they just attacked everybody, but now they're specifically attacking small businesses because they know that's where the quick payout is. And boy, those payouts are getting bigger and bigger. Unfortunately, I wish I could tell you that the cost for these things is going down, but not only are the ransoms going higher and the bad actors asking for more money, but as they get better, they're able to, get a stronger position in the environments and they can ask for more money. And it's really painful for a guy like me to watch, because the thing I know that maybe you don't is that most of this is completely preventable. It actually is something that, for the most part, we can make not happen, or if it does, make a non-event. The root cause of the issue is that changing from a perimeter-based security ideology takes a completely readdressing of everything you've ever learned as a tech professional. And you don't get, it's like as if the law completely changed and California code just became something new. You'd have to relearn everything. And that's really expensive and really hard, especially for people that are mid or late career. EndSight, thankfully, has done it, and we've done it by not inventing something, but adopting something that is just starting to get really good traction. And that's going from perimeter-based security to identity-defined security. Basically, instead of building a castle with all your stuff in the middle, we're throwing a net over each person, and we're saying, I'm going to protect you even if it's from yourself, so that when the bad guys break in, we're able to, first of all, know what's there so we can identify them quickly. We can know when the bad guys are in, which surprisingly is a big problem. Then when they get in, we can actually protect them. Instead of finding that open courtyard with a bunch of stuff in it, they find IT guys behind locked doors with knives, so that we can stop them when they actually do break in. And then making sure that we're prepared for if the worst does happen, so that we can restore our clients to a reasonable state of where they were. Because the challenge is, it's no longer me. I'm not the only one on the IT team. I'm partnered with every single user in my environment. They're part of my team. And we all know we're only as strong as our weakest link. And it doesn't matter how good I am at my job, someone can let the bad guys in by just not being aware or not being diligent. And it's a real challenge. The bigger challenge, I would think, is actually finding what security even looks like. If the Emerald City is security, or reasonably secure, I would say, that we don't even know what that looks like. If you ask 100 IT guys a question, you're going to get 50 answers, and maybe 11 of them are technically right. That's the real challenge. So we created things like the ISO standards and the NIST standard that help us identify what the city looks like, what reasonable security looks like. But how do we get there? That's also a really big challenge. And so we get to look to things like the CIS controls. The CIS controls tell us how. They give us the yellow brick road we can walk so that we can go from where we are to the Emerald City of security. But don't just take my word for it. Let's ask our previous Attorney General, the current Vice President, because in a 2016 opinion, she said that the 20 CIS controls would be something she'd lean on as a reasonable standard, or a standard for reasonable security. I'm just the IT guy. The lawyers will have to correct me if I'm getting those words wrong, but this is what we can look at. And it's the first time that I know of that we've been able to point at a thing that says, do this or you're in trouble. Because from an IT perspective, that's really hard to do. And it even got easier though, because this year they made the CIS 20 into 18. So that's 18 controls, right? Should be really easy to do. Unfortunately, that's not true, because those 18 controls include like 153 steps or something crazy like that. And then they break them down into implementation groups so that it's not just follow the list from A to B. There are all these dependent things upon each other that make it really hard to implement something like this. And it makes it even harder for business leaders to truly understand if they've checked the box of reasonably secure. But fear not. I'm not here just to scare you. I'm here to provide you with something that hopefully can get you from where you are closer to that Emerald City. And I call it the canary in the coal mine. So I don't know how many of you are up to date with your turn of the century mining safety techniques, but back in the day, miners used to take canaries into the coal mines with them, and they would provide them this interesting, I guess I don't say it's not necessarily a partnership of security, but it gave them early warning. You see, canaries have small lungs and they sing when they're scared. And so you could take a canary into a dark hole and it would sing to keep itself company. And if the air ever turned poisonous, the canary would stop singing. And you knew as a miner that it was time for swift and dramatic action. Hopefully you have, I don't know, I'm not going to talk about what you would do, but that would be how you could keep yourself a little bit safe. It was an early warning system. So what I want to give you is, as we look at these, there is an early warning system that I've collaborated with a data privacy attorney to identify. And it's these three controls up top. Now I'm going to show them. These are questions you can ask, But what I want to make sure is that you don't scribble them down right now. I'll do my best to make sure you get a copy of them. I think they'll be in the notes afterwards. But what I want you to do is just think about what happens if you ask these questions to whoever you trust to keep you secure, whether it's a company or an employee. These questions are designed to give you an indicator. They are not an attempt to create work or confusion. They start with things like "at this moment" and "can you show me written?" And what they are is, think of the journey from inventory and control of enterprise assets. If that's a journey of 1 to 100 steps, step 100 would be the list you're asking for. And if they can't produce that list for you, it means they haven't completed the journey. And if they can produce the list, then whether they did the journey well or not, at least they've done the journey. So these questions that you can ask are not, and like I'm saying, don't ask this question and the provider says, give me a week, I'll put it together. Or, let me get you a quote to have that done. That would be an example of no. An example of yes is, can you provide at this moment? And they say, yes, here it is. Or even let me email it later today. You don't have to actually have it in front of them. But the point is, they've walked the journey and they've arrived at the Emerald City for this particular control. If, on the other hand, you ask the question and this is the answer you get, unfortunately, your canary just isn't singing anymore. Okay, now that doesn't necessarily mean that it's time for swift and dramatic action, but it's an indicator, it's an early warning sign that something is not done that should be done. Something is not secure. And I don't know if you could stand up in front of a judge and give a "yes, Your Honor, I did what I needed to be reasonably secure," because they haven't completed the journey. They may be one step behind, or they may have never started. It's hard to know until you call in another expert. But I can tell you, on the journey from Dorothy to the city of cybersecurity, we haven't arrived. So my name is Robert Gillette. Again, I'm with Endsight. Here's my contact information. Feel free to reach out if you have any questions. But now I want to send you over to Chantal Rees to talk about insurance.
Thank you, Robert. Go ahead and share my screen.
Let me get you. Let's see.
Are we all set? Or we need a minute? Okay, wonderful. Thank you, Anne. Okay, I'm Chantal Rees with Rees and Rees Insurance Services, and I've been in the business for about 14 years. I focus on commercial insurance, and I really like to take a proactive and educational approach with my clients. So this is one of the things that we talk most about these days. So let's get right into it. So what does cyber liability cover? Well, liability implies that it's for a third party. So your responsibility to someone else for losses. So you want to make them whole again through this policy, but this covers so much more than that. So it's a little deceiving in the title. It also covers court costs. So if you're going to be sued, the defense costs, the court costs come into play. Also fines and penalties, both for state and federal, which can be very, very high, as we've seen. The triage center for a claim. So how did this happen? What were, the things that led up to this, the attorneys, the public relations thereafter, credit monitoring, all of that. Security liability. So if you accidentally, through this sent malicious code to others, that can be covered as well. One of the main things I find very important about these policies is the business interruption and data restoration aspect. So business interruption would be coverage for your basically, costs while you were down. So income and then costs for vendors, employees, things like that. So if you think about a restaurant, if their roof caved in and they couldn't have customers come in for, months, they still need money to pay their bills and the income that they were earning. This is similar to that. So if you would think of like a manufacturer, a lot of their stuff is robotic these days, and they cannot suffer to be down for even a few days, let alone weeks. So this coverage can really come into play and help keep someone afloat. And also the data restoration, assuming that there are backups being completed, getting that data back in the system and working again. Media liability, they might have something coming out with libelous or slander for others, which could cause a lawsuit. Extortion. So this is a big one. This is the ransom that we've been talking about. So they typically do this in a couple of ways. One is they'll lock the network and encrypt the data, and they won't give you the password without money. And sometimes they don't even pay once the money is given. So that's really a bummer. But also, they will launch an attack where they overload the system, and they won't stop doing that until they're paid. So the policy can kick in for these things. PCI assessments. This isn't for everyone, but if they are in the payment card industry, there are special rules and guidelines, and as well as penalties for the credit cards that are being used. So policy would also kick in there. Cyber deception. This is something that can be left off the policy, but of course we don't recommend that. This is something that is basically someone in the company believes that they are receiving a communication from someone internal. So basically, in this example, an accounting department receives an email. It looks like it's coming from the president. They ask some money to be sent out, maybe via wire transfer. And before they realize that it was fake, the money is gone. They can do this by just adding a simple extra period into the email, or changing one letter, and you may not notice. So it can happen just super fast. And additionally, merchant services will not cover something like this because it was done internally by an employee. So what do we need to actually obtain coverage? Well, it's a pretty simple process for now. Quotes are based on the gross sales of the company. And obviously the industry is going to really affect, how this is rated. So if you're in a highly risky industry for, technology, anything related to software development or IT, cannabis, debt collection, those types of things are going to be higher premiums, and they are going to require more underwriting. But standard industries, they are just a simple online quoting system. However, past claims will affect the premium. So it may even affect if you can get coverage in the future. So they also are going to require that certain things are in place. And this is becoming more and more strict, more and more intricate as time goes on. Robert presented a lot about, the details that are needed to go into this. So minimally, they want to see at least backups occurring in an offsite location, antivirus and firewalls, and then dual control if you're transferring dollars in excess of at least 10,000. It used to be 25, they lowered it to 10. It'll probably go down again. And then different companies are treating this differently. There are application notes that you have to sign off on that you're doing these things. And so we recommend that anytime you get a quote for a cyber liability policy, you talk to your IT firm to make sure that these things are in place. So you're signing something and saying that you are correct in that signature. So what are we looking at in terms of cost? Well, for now, the cost is reasonable. We are seeing really high increases though. This is because claims, as Robert said, it's just getting to be different these days. The Bitcoin, all these things are coming into play. So claims are being paid out more frequently and at higher numbers, and that's affecting the cost of the policies. But for now, we're kind of seeing ranges for legal services, about $1 million in gross sales a year, and this is for $1 million in coverage as well. Pricing can be from about $1,400 to $3,600 depending on the product selected. Domestic services contractor making up to $5 million a year would see similar pricing because they're not dealing with as much data, so they're lowering their amount there. Consulting firm with a contract requirement of $5 million of cyber liability coverage. So I put this one in here so you could see how much the price changes with the level of, with the limits increasing. So 1 million for the first two examples, number 3 is 5 million of coverage. It's almost $14,000. You can't actually get that $5 million in coverage without one of two things. Either your sales have to support it, or you have to have a contract requirement. And this year, in fact, we had to take this to 2 different carriers, because in the past, one carrier was willing to underwrite the whole 5 million and take that on. Now it was split up into 3 million and 2 million because the one carrier didn't want to take that risk. And then lastly, we mentioned that technology firms are going to be paying something different because they rope in not only their cyber liability, but their professional liability or malpractice, errors and omissions, different names for it. They rope those in together. So they're going to see a little bit higher numbers. So for about 90,000 in gross sales, they would be paying about $2,255 a year. So some statistics, I know this is a little small, I apologize, but I wanted it to look good, so it's a little smaller. But just a few to highlight, the average cost of a data breach is coming in at $3.92 million. That is pretty standard across the board. I was reading an article in the California Broker magazine, and it was about 3.65. That's still consistently accurate. So again, that's a huge hit, even for a company that's doing well, a mid-sized company. The average cost of business ransomware attack is $133,000. Now, as Robert presented, that number is continuing to go up. These numbers are a little bit older. They're from 2019, so they are probably a lot higher now. And then in 75% of cases that paid ransom, their backups were compromised. So people might think, oh, well, I back up, I have my data somewhere else, I won't have to pay this out and I can get my data back. Well, you know, you're only as good as your IT firm and your weakest link, as we talked about. So if that's not really up to par, you may not have the backups available. And then lastly, I wanted to point out that 43% of customers are likely to leave if they are hacked, you know, if their information is hacked through your company. So, you know, your loss of trust is huge. You may survive the attack. Can you survive the loss of that business? This slide is actually pretty interesting. It's if 1,000 records were breached, what would be the cost, and where are those costs going? So it's estimating up to almost $1 million for 1,000 records lost. And mainly those payouts are coming from the class action lawsuit. So, you know, the defense costs are coming up with a lot of that. And then also penalties. Our state in particular has some very high penalties. So, you know, you don't want to be doing this alone. You want a policy to help pay for these costs because it can keep you afloat. So common misconceptions. We hear a lot of these, and I'll go through each one kind of quickly, but one is I have coverage on my general liability policy. This may be true. Sometimes it's not, but it may be true. And if it is, typically there's sublimits, which means that it's very low coverage. So the standard is about 50,000. As we saw in the previous slide, that's not going to really get you much. We recommend $1 million minimum. My IT firm handles these issues for me. Well, as we've seen, it's a partnership. You're only as good as your weakest link. If the employees accidentally let the bad guys in, that's not going to do anything for you. I don't keep anything on my network. It's all stored in the cloud, or I don't keep any sensitive information on my computer. Well, you might not think you do, but as we know, our computers kind of store things that we don't even know about. And also, you might not be the target. You might be somebody that they are using to get to someone else. So for example, let's say a contractor is going to go for to bid a job, and it's a celebrity's home, and they take an iPad and they use the Wi-Fi to get in and start doing their thing and coming up with a bid. Well, if they have malware, that can now go into the Wi-Fi of the celebrity home. They can access their Alexa, all these things that are attached to the Wi-Fi. So it might not be about you. It might be about who you're interacting with. I'm a small company, no one will want my data. As we've seen, again, this is not true. We have amateur hackers that are getting playbooks to do this. They are not going after the pipelines and the food companies. They are going after the mom and pops because it's easier. And as we've seen, they don't spend the money on the infrastructure to deal with this. So it's a lot easier to get money from them. And then lastly, we only keep paper files, so data breach is not possible. Well, that's not true, because if someone physically comes in and can steal documents, like a medical office, for example, they can come in, copy the information, or physically take it out of the office. That's considered a data breach. Or if a computer itself is stolen, that's also considered a physical data breach. So it would apply there too. So some examples, you probably all remember the large data breach that happened in 2013 with Target. That actually occurred because an HVAC contractor was piped into their system for billing. And one of the employees at the HVAC company clicked on a phishing email, and it was a direct conduit into Target. So again, it's not always about you, but who you interact with. And it is your responsibility to keep the clients, prospects, and employees' data safe. Another one, in May of 2020, actually, we heard of a high-profile law firm in New York, multiple A-list clients such as Madonna, Lady Gaga, Bruce Springsteen. They were asked for ransom, a pretty penny from what we understand, to avoid releasing sensitive data, proprietary information. And we don't know if this was paid or what happened. We do know the FBI was looking into it, but I can't really find anything on the back end about that. You'll see more and more universities and municipalities being affected. University of San Francisco, or UCSF, actually paid $1 million to get some information back. But I know there was another university on the East Coast that refused to pay, and some of the HIPAA medical information of the students was actually released on the internet. Some real life examples that I know of, like that I've actually been privy to. One of the clients in Orrin Associates, my partnership firm, they had an email come from an owner that, so they thought, requesting $25,000 in gift cards. They took the gift cards out, mailed them to various addresses, and then found out later that it was not real. And they did not have a cyber liability policy, so they were out that $25,000. And I know if that happened to me, it would be a huge hit. So I can only imagine. And then Whiting Turner, an accounting firm, was breached in 2016. This one is very intense because they had W-2 and 1095 tax forms exposed. And so they found out only later that fake taxes were filed in the names of the children and some of the family members. And so you can only imagine how long the claims and discovery and all that would be for this type of claim. It just is going to go on and on. So, it's unfortunate. Anyway, that's everything for me. So I thank you very much for your time. I really enjoyed presenting to you today, and I will send it back over to Anne. And thank you again.
Hello, everyone. I am Ann Wolf, the Education Events Director for the Contra Costa Bar Association. And I want to thank Chantal and Robert and Joshua for the thought-provoking program today. I think we do have a lot to think about, and we probably need to do a few things too. And I'd also like to thank David Ratner and Judge Flyer for helping to coordinate this program. So please stay tuned for the live Q&A session coming up after a few announcements. So the materials and the evaluation forms for this program can be downloaded from this session page through the Files tab above the chat. Attendance certificates will be available after the Thanksgiving holiday. If you are a CCCBA member, your attendance certificate will be in our website in your member profile. If you are a non-member or would like more information about how to get your attendance certificate, look for information under the FAQ tab on the main screen. And if you're having technical difficulties, head to that FAQ tab as well. Okay, so you are now invited to join the live Q&A session with our panelists, Chantal Rees, Robert Gillette, and Joshua Bevitz. Below the screen on which you are watching this session is a link that will take you directly to the live Q&A session. Okay, click the link, get ready to join the live Q&A, and I'll see you there.